Hello, everyone. Welcome back to the show. Well, whether you've been in the workforce for a short or long period of time, you have rights as an employee, but sometimes things happen that may leave you wondering whether you're being treated fairly. For example, could you be required to take a drug test? What should you do if you're sexually harassed? What if you are hurt on the job? If you are an at-will employee, do you have any protection? There are plenty of questions when it comes to employment law, and we are happy to welcome our guest today, who is well-versed in this area, and he's here to help us all better understand it.
Attorney Glenn McGovern has over 3 decades of experience practicing civil rights law, personal injury, product liability, and employment law. Glenn, thanks for coming on the show. We're looking forward to this discussion. Why don't we start with the overriding description? What are employment discrimination claims? Tell us the basic explanation.
People generally misunderstand that. Generally, like was mentioned, you're at will unless you got a contract. Employer can terminate you with or without cause. You can say, I don't like your socks, you're fired. That's it. So generally you can do that. But you have to fall under a particular statute to be protected. And basically, they can't discriminate against you under statute, federal and state law for certain things. And briefly, it's like race, creed, color, national origin, sex, smoking, pregnancy, disability, and for whistleblowing. So that's a new hot area.
So if you are an at-will employee, you do have some protections under the law.
Yes, but only in those limited bases.
Very limited.
So if it's personality or something else, which is common, then they can fire you, or you don't friend your boss on Facebook and you get fired. I've had that happen before.
Really?
That sort of thing.
Wow,
yes.
that's very
completely legal. Or you're gay and you don't live in Orleans Parish, which has a gay ordinance, but otherwise in state law, federal law, you don't have any protection for that.
It's interesting that there are ballots all over the country about gay rights and the Defense of Marriage Act, really in dispute right now in the U.S. Supreme Court. But let's talk, just make sure that everybody understands, being an at-will employee, that's pretty much everybody unless you have a contract with your employer. Your employer says, I'm going to give you a contract to come work for me for the next year or the next 2 years. Is that what you mean?
Right, that's every state in the union except for 1 or 2.
Okay, so basically everybody who has a boss, that's an at-will employee. And that's pretty much everywhere, definitely in Louisiana.
Definitely in Louisiana. You can be fired with or without cause or false cause.
So when it comes to complaints, does the size of the business actually matter?
Yes, and that's another thing people don't understand. If I have 3 employees, for example, I can sexually harass or racially discriminate, and that's completely legal. It's not going to violate state law or federal law. Governor Foster raised the minimum number of employees to fall under the state discrimination law to 19. Federal law is 15. So unless they got 15 employees, then Title VII, which prohibits sexual harassment, racial discrimination, etc., doesn't kick in. FMLA may require 50 employees for FMLA to kick in. So each statute has a different number.
Well, you mentioned Title VII, and that's something that we talked about earlier. It's very important to understand what Title VII is.
Yeah, and let's just, and also FMLA, that's the Family Medical Leave Act.
Family Medical Leave Act, right.
But employment discrimination, that is, if you are a mom and pop operation, you're not bound by the federal or the state laws which say you may not discriminate based on race, religious creed, color, and the basic and gender, things like that. Now, if you are a smaller company, it's kind of shocking to hear it, but Glenn practices in this area of law. Mom and pop operations, they can fire you because one day they wake up and they decide they don't like people with red hair. They don't like the color of your socks or your personality.
Right.
They can sexually discriminate against you. Now, if somebody assaults you, well, that could be a criminal violation. You might be sued because of an individual assault and battery, and you could be sued both civilly and criminally. But so we're clear. The Title VII under the federal and under the state, there's another, I don't know what exactly it's called, just state
law, they have a state
employment
statute.
discrimination statutes. If you are more than 19 employees in your company in the state level, more than 15, that's 10 and 5, 15.
Yeah, 15 or more, 19
15
or more.
or more, 19 or more in federal state, then you are subject to these discrimination laws. Now let's talk about what are your rights if you believe you've been discriminated against, what are your rights?
Well, basically, the way it works under Title VII, and state law mirrors it, is what the Congress did is they passed this because after 1964, the discrimination laws, segregation laws, there was a problem. So they said, well, the government can't do it, so what we'll do is we're going to create a little army of U.S. attorneys to go out there, and we're going to give them attorneys' fees, and we're going to award punitive damages so that, you know, this is eradicated in our country. And that's the beauty of Title VII, and it's worked pretty well to change our society as we know it today.
But what do you say to those employees who are watching the show who feel like they are being mistreated, that what is being done to them is illegal, or perhaps the company is doing something that they believe is illegal? What is the first step? What should they do? I imagine, first of all, they're just terrified to have this information and don't even know where to go.
Well, one of the things that's a good topic because that's misunderstood. What you have to do, first thing you should do if you think you're discriminated against, is file a sworn complaint with the EEOC. Now, they got a website that you can fill out a form. That doesn't count. You got to file and sign a sworn complaint. Once you do that, you're protected against retaliation. It's a heck of a lot easier to win a retaliation suit, 98% chance of success, versus a discrimination suit. So you may have a case where you can't win on discrimination, but you got a really good retaliation suit. And so jurors don't like that.
And so you should go to the EEOC person there at your place of work?
Nope. You go to the EEOC HR. You know, it's like there's a cartoon in the paper with the HR manager, the evil HR manager. You want to file with the EEOC, and you only have 300 days in Louisiana.
That's
Some
important
states you have
to know.
180 days. That's very important. If you don't file, I can't help you. I can't do anything. You have no federal cause of action. Now, state law, you've got 1 year to file from date of the incident, or date that you know you're going to get terminated, or date you're terminated. So you got to watch that.
Yeah, let me do a little recap on this, because a couple of very important things. EOC,
Equal Employment Opportunity
Employment.
Commission, 1555 Porter Street.
Okay, very important. Okay, you need to just physically go there, ask for the paperwork to file a grievance. Retaliation, retaliatory discharge. That's when your employer finds out you're complaining, you're filing a complaint, or you're thinking about filing a complaint, and then the employer retaliates. Your employer fires you. Happens all the time. I mean, people come see me about this. Glenn sees people about this. If you file this complaint, 98% statistically, the odds are you're going to be in good shape to say, you can't fire me because I recorded my complaint before you fired me. Employers are vindictive. They'll fire you if you're making trouble for them. One more thing, and I want to cover this in a little more detail, this whistleblower business. It's extremely important. If you're aware your employer is maybe not sexually harassing somebody, but they are involved in some illegal operation. Glenn, give us a short definition of whistleblower.
We always interview, the people that call in because they may have an employment problem. And part of it may be fueled by many things. One of them may be they complain about doing illegal acts in the workplace, or the employee doing illegal acts. There's a state law and there's a plethora of federal laws that protect workers who report illegal activity. If you know illegal activity, you should report it to a law enforcement agency and to any regulatory agency, and you should report it to your supervisor, and then you're covered. Each one's different. You need to consult with an attorney to make sure you do the right thing. If you're retaliated against, depending on the corporation, if it's a public traded corporation and retaliated, it can be a federal crime. It can be a felony. A lot of people don't understand that. But this is an exciting new area of the law, and for people especially people, and there's rewards that are paid to employees, like under the Federal False Claims Act, you can be paid 11 to 31% reward.
Wow, interesting. Okay, we've got more to talk about, so stay tuned. Glenn is going to be with us to take your questions, so stay with us. We'll be right back. Hello, everyone. Welcome back. Time now to get you involved in the show. All week long, we've gotten questions from our viewers on Twitter, Facebook, and email. So let's get right to them. Our first question comes from Robert in Mandeville, and he has this question about the differences between at-will employees and contract employees, and what rights do you have if you fall under either one of those categories?
Well, At will, most employers are at will if you don't have a contract. If you got a contract, the contract terms would govern. But at will, they can fire you with or without cause or for a false cause. So basically, the only protections you got are under existing laws. It's like the old days with the feudal system. They had little boxes, and they would put a writ in the box, and you had to fit trespass or this or that or battery or assault, and you got to fit sexual harassment, racial discrimination, Title VII. You got to fit in one of those, whistleblower, surveying doxing. If you don't fit in that, you don't have any protection.
Okay, and as you were saying just not very long ago, pretty much everybody falls under that category of being an at-will employee. That's pretty much all of us,
people.
Right?
Yes.
Yeah, most people. Okay, our next question comes from Tracy in New Orleans. She says, how can I report unsafe working conditions anonymously? This goes back to that whole whistleblower issue.
Well, what you should do is contact OSHA. They have a website. They have an office in Baton Rouge, and you can fax them a letter and ask to be anonymous. I'll tell you, it doesn't mean you're going to be anonymous the whole time, but they can breach that. But you can ask for that, and they'll try to maintain that as good as possible, as well as possible. But yeah, you can send a letter to OSHA on unsafe working conditions, and you've got to do it. There's time limits. I can't remember on that statute. I think it's 90 days or something like that.
90
it's
days
tight.
from what?
From the date it's going on or it's happening or whatever the event's happening. If there's an event, it's on a case-by-case basis. But
Yeah, I would like to just add to that and kind of get back to what we were saying at the end of the last segment. Remember, if you are aware of an illegal activity going on, and Glenn, there's just never enough time to talk about these things. If you are a whistleblower and you report illegal activity that's taking place, you may end up being able to benefit because if you expose fraud, corruption, illegal activities, and the case ends up producing money, you can get a percentage of that. You want to just flesh that out for us?
Yeah, well, basically, whistleblowing is reporting illegal acts or improper acts under law. And so when you report these to law enforcement or your supervisor, each statute's different, but basically you're protected. And employees make the mistake a lot of times, especially women, single parents, they don't want to report sexual harassment or whatever because they say, oh, they're going to fire me. Well, actually, you're better protected. Once you file that complaint, in writing sworn complaint, they can't fire you. You're protected, and the employers know that. They're not going to be stupid and fire you for that. Because statistically, jury verdict research says 98% of the retaliation cases, the employee wins. So you want to file those complaints and document that. So it's any illegal activity, you can, and under some statutes you can be rewarded, you can be issued punitive damages, you can be issued under False Claims Act, a percentage of the recovery, if there's millions of dollars involved, and you report that, and you're the first one.
But we want to be very clear with Tracy. If she does know of something that's going on and she does report it, maybe initially she may remain anonymous, but being realistic about it, her anonymity won't last for long.
Yeah, and let me say this also to Tracy. Most lawyers, somebody like Glenn, you can go to the Power of Attorney website. There'll be links to get you to free information, and we'll put information from Mr. McGovern's website. And you can also Google or find Mr. McGovern. Find him through our website. Find him on the internet, Glenn McGovern. And I'm betting that he'll either talk to you directly or talk to my office, and we'll give you some assistance on this, where an attorney who does employment law will give you some further insights specific to your concerns. Or if it's not you, it's one of your friends, you can put them in contact with one another. That's another suggestion. One more thing on retaliation. You may be an employee who's hurt on the job. It's a workers' compensation thing. It's not an employment discrimination thing. An employer sometimes will retaliate against you because you have dared to ask for wages while you can't work, and you're entitled to workers' compensation benefits. There's laws on Louisiana's books that say if an employer fires you because you're making a workers' compensation claim, you're asking for workers' compensation, you can get not only your workers' compensation wage benefits, medical benefits, but also penalties against that employer, including attorney fees, because the employer retaliated against you, fired you, for attempting that. So there are similar laws.
When you file these complaints, really in terms of the length of time that it could take before your case is settled or before you get any sort of restitution, I mean, people should be aware that this is something that could take a long time. I mean, they should be in it for the long haul, correct?
Right. It just depends on what court, where it's filed. It goes a little quick in federal court, but you can have appeals and that sort of thing. But like this lady here, Tracy, on OSHA, they'll jump on it. They react pretty quick, and they'll make a decision on that.
Okay, all right. Let's go to Stephen from Slidell. Here's a question. He says, can my employer drug test me without my permission?
Okay, usually most, that's governed under state law if you're in Louisiana. Most of them have it in the employment manual, whether, you know, what the rules are for drug testing, and they can do it. And then you've got other laws like workman's comp law. If you have an accident, they can drug test you. And there's certain rigorous requirements they got to meet for that drug test. So you can't just pee in a cup and they say, okay, you know.
Well, so your employer can't just pop up one day and say, we want to drug test you.
No, they have to implement a policy and everything, and it's in the employee handbook. And there's a whole section. We're really good on safeguarding that.
Okay, all right. Scott writes in and he says, are there any protections for gay or lesbian employees under Title VII?
Nope.
That's the short answer?
That's
and
it.
the long
You're
answer?
out.
And the answer.
You're out. You may have, in Orleans, they have a Human Rights Commission and they have an ordinance. Your city may have an ordinance, but no, you don't have any protections right now.
Okay, all right. Did you want to add something to that?
No, just that's one of those things where there are certain things covered under Title VII, there are certain things covered under our state laws, but the gay or homosexual rights or civil rights for same-sex unions, not covered.
Not covered.
Now, you know, let me say this. If you're sexually harassed by another gay manager or whatever, that may be covered under sexual harassment because that's sexual in nature, but not because you're homosexual.
I see. And when it comes to filing those kind of complaints, do you find that people just don't know how to handle those situations or don't know what is reportable?
Yeah,
what are you finding?
Most people, even, you know, educated professional persons, I'm shocked, they don't know where to go. You go to the EOC 1555 Poydras Street, that's the only one in the state, and sign a complaint. But they don't know, and also they don't know, state law is 1 year prescriptive period for torts. Under EOC, it's 300 days. So if you don't file it, if you wait longer than that, you may only have a state cause of action, and you want to get that federal cause of action.
Let me repeat that. Under the EOC rules, it's 300 days, not 365 days, 300 days. Again, go to johnredmannpoa.com, and we will have that information there in case it's not clear. You don't have a pencil and paper during the show.
Okay, here's a quick question, our last one for this time. It says, social media, and this comes to us from Troy, social media such as Facebook is ubiquitous these days. Does my employer have grounds to fire me because of writings and photos taken during time off work?
Yeah, this is a real hot area that's rapidly developing now. And there's questions. It's even some employers are requiring you to give them your password so that they can check your site. And so the law is in flux. There's no cases in Louisiana on that. The only cases are on discovery. When you file a suit, can they get access to your Facebook site?
Okay, so we're running very short on time. So if an employer does ask me for my password, am I required to give it or no? Legally, do I have to do that?
There's no law on the point.
There is no law.
There's only a couple of cases, and basically they say no. And the way you have the privacy settings seems to be critical in those cases. If you've got privacy settings, the employers generally don't have access to that.
Okay, all right. Well, we have to wrap it up. We are completely out of time. That's all the time that we have. We hope that you will join us again next week, same time, same place.
Thanks, Glenn, and thanks everybody watching at home and online. Remember, you can visit our website, johnredmannpoa.com, and watch every episode of the show, as well as get all kinds of great legal information. Thanks, and we'll see you next week on